Hello and welcome to BYJU'S Exam Prep IAS. The big news for today is that the Congress leader and the Lok Sabha MP from Kerala's Wayanad, Mr. Rahul Gandhi, has been disqualified after yesterday he was convicted by the Surat court for 2 years in prison for a defamation case that goes back to 2019. Now, after the Surat court's decision came out yesterday, there were a lot of rumors that Mr. Rahul Gandhi might face disqualification very soon. In this video of the big news, we'll be discussing what exactly is a law under which members of parliament or MLAs can be disqualified if they get a jail term. What are the important Supreme Court cases in this regard, and also what is the reaction coming in from the government and from the opposition. Now, this is the official letter coming in just today from the Secretary General of the Lok Sabha, under which the announcement has been made that Sri Rahul Gandhi, member of the Lok Sabha from the Wayanad parliamentary constituency of Kerala, has been disqualified from the membership because of his conviction on 23rd of March by the Surat court as per the provisions of section 8 of Representation of People Act of 1951. As I said, the court case goes back to 2019. It was a period when the Lok Sabha elections were approaching. There was a campaigning going on, and Mr. Rahul Gandhi made a statement with respect to the surname Modi, associating this surname with certain criminals. And this is why this case was filed against Mr. Rahul Gandhi. Now, please remember, the Prime Minister did not file this case, does that because Mr. Gandhi used this name and identified this with certain criminals. There were other people with the same surname who were hurt. They were the ones who filed the case. So the case was not filed from the side of the Prime Minister. This Surat case ruling mainly is because of this comment made by Mr. Rahul Gandhi. I would not like to read it out. If you want, you can read it from here. Section 500 of the IPC talks about defamation and the punishment associated with it. This says that for defamation, if the crime is proven, maximum punishment can be 2 years of prison and a fine along with that. Now, does the judge have to give maximum punishment every single time? It depends on how the judge perceives the case. In this case, the Surat court said that despite the Supreme Court telling Mr. Rahul Gandhi time and time again not to make personal remarks, not to have personal defamation against the members of the other ruling party, Mr. Gandhi did not adhere to these regulations and he kept on making such statements during the election campaigning. And that is why, as per the judge, he deserved maximum punishment. Interestingly, the court itself suspended the sentence to be carried out for 30 days, allowing Mr. Gandhi to appeal in the higher court. A bail bond was also issued for 15,000 rupees of surety. Now, what exactly is the law under which lawmakers are disqualified in India? There are mainly three ways of disqualification of a member of parliament. First, Article 102, which talks about disqualification of member of parliament, and Article 191, which talks about disqualification of an MLA. Both these articles say that the lawmakers may be disqualified from their seat because of reasons such as holding an office of profit, losing the citizenship of India, being of unsound mind, or being insolvent, etc. The second way in which the members of parliament can be disqualified is under defection. As you know, the 10th schedule of the Indian Constitution has anti-defection law. In simple terms, if the members of parliament change their party, vote against their party, resign from their own party, these are some of the circumstances under which the member of parliament may be disqualified. This decision of disqualification is taken by the presiding officer of the House. First and the second do not apply to Mr. Gandhi in this case. Third is the reason because of which Mr. Gandhi now stands disqualified. This is under the Representation of People Act 1951. The law talks about disqualification for conviction in criminal cases. Now, this act, that is the RPA 1951, has many sections. For our importance right now, we are focusing on four sections: 8, 9, 10, and 11. Section 8 says disqualification might happen in case of corruption, disloyalty to the country, or entering into government contracts. This is not applicable to him. Second, Section 10, disqualification would happen for failure to lodge an account of election expenses. Again, not eligible for him. Section 11, disqualification for corrupt practices. Not this one. Section 8 is the one where Mr. Gandhi has been disqualified. Section 8 says disqualification may result for conviction of offences. It is aimed at ensuring that criminalization of politics reduces and that those politicians that have criminal cases against them, those politicians that have been convicted of certain crimes, remain away from politics. In section 8 also there used to be 4 parts. Now there are 3 parts. The fourth one has been removed. First part says offenses such as promoting enmity amongst different groups, ensuring that they take part in bribery, or having undue influence at an election would lead to disqualification. Part 2 of Section 8 says that if a lawmaker indulges in hoarding, profiteering, adulteration of food, or offences such as dowry, they would also be disqualified. For Mr. Gandhi's case, it is part number 3 that is applicable, which says a person convicted of any offence or sentenced to imprisonment for at least 2 years shall be disqualified from the date of that conviction and 6 more years. So, if a person has been, let's say, sent to jail for 5 years, then that person will stand disqualified for 5 years plus 6 more years. So, whatever your jail term is, plus 6 more years, you cannot fight elections. There used to be part 4 also of section 8, which has now been taken away in the Lily Thomas case. We'll discuss about it in just a bit. There's also a very important Supreme Court case in this regard, that is the Lok Prahari case of 2018, in which the Supreme Court had said that if the lawmaker's conviction is overturned by an appellate court, as soon as the conviction is overturned, the disqualification will go away. So if the Mr. Rahul Gandhi, let's say, goes to a higher court, the high court, let's say, stays this conviction, then his disqualification order will be taken back. This was told by the Supreme Court in the Lok Prahari versus the Union of India case in 2018. Also, the Lily Thomas case itself is extremely important. Lily Thomas, as you can see in this photo, is a very famous Supreme Court lawyer. That is why you will see the name Lily Thomas case in not just this but multiple important cases of the Supreme Court. It was in 2013 that the Supreme Court in the Lily Thomas case had struck down Part 4 of Section 8 of the Representation of People Act. In simple terms, earlier, Part 4 had said that even if the lawmakers get a punishment of 2 or more than 2 years, they would get at least 3 months of time to file an appeal in the higher court. For these 3 months, they will not be disqualified. But now that has been taken back. So now, as soon as the Member of Parliament gets convicted for 2 years or more, the disqualification will be immediate. You can appeal, and once the appeal is heard, the conviction is stayed or overturned, then disqualification will go away. But till that time period, the disqualification would be immediate. Also, the government of India usually does not want to rush into such cases. For example, recently, Member of Parliament from Lakshadweep, Mr. Faisal, was convicted by a court in Lakshadweep and he was declared to be disqualified from Lok Sabha. However, just within a week, the Kerala High Court suspended the conviction and the Lok Sabha Secretariat had to take back the order. Mr. Faisal immediately challenged it in the Supreme Court because the Election Commission had declared his seat as vacant. Following the Supreme Court order, the Election Commission also had to take back their order and the seat was again given to Mr. Faisal. That is why in these kind of cases involving Mr. Rahul Gandhi also, the decision can change very quickly depending upon how the higher court perceives it. This is it for today's big news video. This news is still developing, so we would suggest you to keep an eye on what happens in the coming days in the higher courts. Thank you so much. Have a good day ahead. Jai Hind.